Dear students, subscribers and the viewers, welcome to the IAS Mentor. We will proceed with the next lecture, that is lecture number 39 in our series Indian Polity, where the objective was to provide a comprehensive idea about the subject Indian Polity. And before I proceed further with today's lecture, where I'm going to deal with the right to constitutional remedies under Article 32, which is in fact one of the most important fundamental right. In fact, Dr. B.R. Ambedkar called this provision to be the very heart and soul of the Constitution. In fact, I have given the explanation as to why it is called as the very heart and soul of the Constitution. Anyways, I'll discuss that later. Now, before I proceed with the lecture today, there are a lot of students who are reaching out to me asking me that, sir, can you cover a specific book like LAXMIKANTH? Will you cover both for prelims as well as mains? So don't worry about all those things. I have already done a series, but maybe this series is not exactly replicated in the same manner. For certain reasons, I am not doing it in the same way, but this will be definitely a better version of my previous version. Because I know I am the person who's doing both the things, and this is going to be a better version of the previous series that I have done. And of course, both your prelims as well as your mains relevant things will be covered. But having said all those things, the students have to do something on their part. But definitely this course is going to help them immensely, benefit them, especially for your prelims as well as for your mains examination when it comes to UPSC aspirants. The other state service examinations, they can also follow this, which I am sure it will be quite beneficial to all of them. Apart from that, if you have clarity, if you lack clarity, or if you need a specific topic to be discussed, you can reach out to me through my Instagram account or through my Telegram channel, and if time permits, I will do that as well. Okay. So with that, I'll move to the lecture. And before again I go to that, one small announcement that I wanted to make is that there's a series that I've done on how to prepare for UPSC personality test. This series I have done keeping in mind that most of the students, especially the students who are the first time beginners or first time who are preparing for this examination, they do have to learn a lot of things on their own, which I also faced when I started preparing. I was the first to prepare for UPSC from my family and from my background. And then a lot of things I've learned through what is called as trial and error. And it takes years for you to learn the right thing. So because I feel that I possess some of the knowledge which I can share it with most of the students, and it can really benefit all those students, keeping that in mind, because it took years for me to learn all those things. Keeping that in mind, which also helped me to be successful in this examination. So keeping that in mind, I have shared some of my strategy as to how it helped me to do well in the personality test, where I was able to score 200 marks, which is only 5 to 10% of the people will score that particular mark. So why I am suggesting to all the students who might be even new to the preparation is because most of the students feel that yes, they'll go to the interview stage and then they'll prepare for the interview, which is not going to happen. It is not going to work that way. Yes, I'm sure that if you read well, probably you can clear both your prelims and mains, but personality test is not just about your intellectual abilities. Personality test is testing your personal attributes. The board members should be satisfied that you have all the qualities or most of the qualities to become a good civil servant, which I think that the moment you make a decision to prepare for the examination, you should start preparing for your personality test as well. Although I'm not saying that you'll have to spend a lot of time, but you can keep this consciously in your mind as to what are the qualities probably you'll have to develop, and then it becomes part of your subconscious mind. So keeping that in mind, I have made 4 videos, and all the 4 videos, short videos, it will give a lot of insights, which actually help me to do well in the interview test. Okay, so you can watch that, and I would say that you should watch that. And in fact, if any of your friends or family members, if they are preparing and if they are appearing for UPSC personality test, you can also recommend them these videos. All right. So with that, I'll just go to the next lecture, that is lecture number 39 in our series, that is Indian Polity. Now we'll move to the next article or the next theme of fundamental rights, which is basically the right to constitutional remedies. And what do you understand by right to constitutional remedies? In fact, we have discussed that the part 3 of the Constitution is what is called as a Magna Carta of India. When I say Magna Carta of India, that it is a great legal charter which was signed by the British king and his rebellious barons, the nobles who rebelled against the British king. The idea is that they wanted their rights to be protected from the king, and so the rights of the people as well. So similarly, what is protecting the rights of the people against the state today is the fundamental rights, which is there in the part 3 of the constitution. And that is why the part 3 of the constitution is also called as the Magna Carta of India. But however, within part 3 of the constitution, there's one article, that is article 32, which Dr. B.R. Ambedkar, the chairman of the drafting committee, called this to be what is called as the heart and soul of the constitution. That means he has laid a lot of importance upon this article 32, because article 32 provides for what is called as right to constitutional remedies. So what is this right to constitutional remedies? That means, while all the other fundamental rights which we already discussed, right from article 14 we have seen till article 30 in the last lecture. Now all these articles are giving lot of rights to us and we can exercise those rights. But the question is, what if these rights are violated? How do we get that enforced in a court of law? Because the rights would become meaningless unless and until they can be enforced in a court of law. So it is exactly what is done by article 32 of the constitution. Article 32 of the constitution gives us the right to get it enforced in a court of law when any of the other fundamental rights are violated, or in other words, getting the fundamental rights enforced in a court of law when it is violated in itself is a fundamental right by virtue of article 32 of the constitution. And that is why Dr. B.R. Ambedkar called article 32 to be what is called as the heart and soul of the constitution. Now article 32 of the constitution is empowering the Supreme Court of India to issue writs whenever any fundamental right is violated. That means, suppose let us assume any ordinary citizen is there, or for that matter any individual is there. If he is conferred a fundamental right under any of the provisions in the constitution, if he feels that his or her fundamental right is violated by the action of the state or by the action of a private individual, depending upon what type of fundamental right it is. So in that particular case, the affected individual can go to the Supreme Court under article 32 and seek remedy by filing a petition. So that means the individual has to take it to the notice of the court. And in this case, under article 32, we can directly approach the Supreme Court of India when our fundamental rights are violated. So when we approach the Supreme Court of India under article 32, the Supreme Court is empowered to issue certain writs. That is what is very, very important. So what the Supreme Court can do under article 32? The Supreme Court can issue what is basically called as writs. And in fact, the Supreme Court can issue 5 types of writs: the writ of Habeas corpus, the writ of Mandamus, the writ of Prohibition, the writ of Certiorari, and the writ of Quo-warranto. These are the 5 types of writs that can be issued by the Supreme Court to protect the fundamental rights of the people whenever the rights are violated. But what is the type of writ? Because I said 5 types of writs. What is the type of writ that the Supreme Court will issue depends upon the nature of the fundamental right. It is not that the same writ will be issued in all the cases. Depending upon what writ is violated, accordingly, depending upon what right is violated, accordingly writs will be issued by the Supreme Court. So basically, what is a writ? Writ is nothing but a directive or a direction, or you can say it is a directive or a direction which is given by the court to the concerned authority, which the court have felt that which has violated the rights of the people, and thereby to provide some remedy to what is called as affected individuals. That's basically what is called as writ. So this is the basic understanding you should have. So as we'll proceed, we'll try to understand the different types of writs. Okay, so before I proceed, I wanted to ask one question to all the students, because I already discussed this. Now the Supreme Court can issue writs under article 32 of the Constitution in case of violation of the fundamental rights. But similarly, in case of violation of the fundamental rights, not necessarily the citizen should approach only the Supreme Court. To the Supreme Court, the citizens can directly approach, no doubt. If they want, they can directly approach the Supreme Court of India, but that's not the only court. They can also approach what is called as the high courts in India. So can you tell me as to what is the article that gives the power to the high courts to issue writs in case of violation of the fundamental rights? Or in other words, which article empowers the citizens to approach the high court, and therefore the high court can also issue writs for the violation of what is called as fundamental right? So I'm looking for the answer. If you know the answer, you can put it in the comment box. while Article 32 is for the Supreme Court. And what is the article which is giving the power to what is called as the High Courts in our country? And under the respective article, the High Court can also issue writs. The High Courts can also issue 5 types of writs, that is writ of Habeas corpus, Mandamus, Prohibition, Certiorari and Quo-warranto. So all these writs can also be issued by the High Courts. But there is a small element of difference with regard to the writs issued by the Supreme Court and the writs issued by the High Courts. In fact, if you look into the Constitution has given wider powers to the High Court with regard to what is called as the writ powers. Now, why do I say with regard to the writ powers, the High Court has got wider powers, or with regard to the writs, the High Courts have got wider powers? It's because of the reason that the High Court can issue writs not only for the protection of fundamental right, but also for the protection of what is called as legal rights. So this is what you'll have to understand. So while the High Courts can issue writs for both protection of fundamental as well as the legal rights, but whereas if you see that in case of the Supreme Court can issue writs, and the Supreme Court can issue writs only for the protection of what is called as the fundamental rights. So this is the basic understanding you should have. So with regard to the nature of rights which is violated, the High Court has got wider jurisdiction, because the High Court can issue writs not only for the protection of fundamental rights, but also for the protection of what is called as legal rights as well. But whereas the Supreme Court can issue writs for what? Only for the protection of what is called as the fundamental rights. Now you can ask me a question that the highest court is the Supreme Court, but whereas the High Court is given more powers with regard to what is called as the writ powers, because it can issue writs even for the protection of what is called as legal rights. So if you know the answer, you can put it in the comment box. Why the High Court is given more powers to issue writs for protection of even the legal rights, whereas the Supreme Court is not given. The Supreme Court is not supposed to look into all those things, whereas the High Court can issue writs even for the protection of what is called as legal rights. And I'm quite sure that you can recollect as to what is the difference between a fundamental right and a legal right. So what is a fundamental right? Fundamental rights are those rights which are guaranteed only in the Part 3 of the Constitution. But whereas what is a legal right? Legal right are those rights which flows from the ordinary laws of the land, which is through the law made by the Parliament or the law made by the state legislature. Say for example, Consumer Protection Act, which gives the consumer the rights to have quality service, quality products when they purchase from the shops. And if there's a substandard service or a substandard product, we can approach the consumer courts if the seller is not replacing the product or the service. Now this is basically a right that is given to each and every individual, but however this is not a fundamental right. It is not coming from Part 3 of the Constitution. So whatever right that comes from the Part 3 of the Constitution, that's a fundamental right. Any right that is flowing from the ordinary laws of the land, that's a legal right. The High Courts can issue writs for the protection of both fundamental rights as well as legal rights, whereas the Supreme Court can issue writs only for the protection of what is called as fundamental rights. So when it comes to nature of rights, who is having wider jurisdiction? The High Court is having wider jurisdiction. But whereas on the contrary, when it comes to the territory, who is having the wider jurisdiction? The Supreme Court is having what is called as a wider jurisdiction. In other words, the Supreme Court can issue writs for the protection of fundamental rights wherever the violation of right has happened throughout the territory of India, not necessarily in a particular state. Anywhere across the territory of India, wherever the incident has happened by which there is a violation of fundamental right, the Supreme Court is empowered to issue writs. And we know what is the territory of India, which comes from Article 1 and therefore from Schedule 1 of the Constitution, from Article 1 to Schedule 1. But whereas when it comes to the High Court can issue writs only for the protection of fundamental right when it has happened within the territory of the concerned state. So it does not exercise any jurisdiction beyond the territory of the concerned state. So with regard to territory, the High Court has wider powers. With regard to nature of rights, the High Courts have got wider powers. So this is the basic understanding you should have. So I am quite clear that the basics are clear. Now, before I move forward to the different types of writs, that is the individual writs, you should also make it very clear in your mind that apart from the Supreme Court and High Court, is it possible for any of the other courts to issue writs for the protection of fundamental rights? High Courts under which article? I wanted the answer from the students. Supreme Court under which article? Article 32. Is it possible, apart from the Supreme Court and High Court, any of the courts in India, that is the subordinate courts in India, apart from Supreme Court and High Court, to issue writs for the protection of fundamental rights? So till this point of time, no other court is empowered in our country to issue writs for the protection of what is called as the fundamental rights. Only the Supreme Court and the High Court under the Constitution are empowered to protect the fundamental rights in case of violation of the fundamental rights. But however, you should be aware of Article 32 Clause 3. If you go to Article 32 Clause 3, that is within Article 32, a specific clause is there, Article 32 Clause 3, that gives a power to the Parliament to make a law, and by that law, the Parliament can empower any of the other subordinate courts also to issue writs for the protection of the fundamental rights. That means the understanding you should have is, if the Parliament makes a law under Article 32 Clause 3, because Article 32 Clause 3 empowers the Parliament to do so, and under that law, if the Parliament empowers any of the other subordinate courts to issue writs, those subordinate courts can also issue writs for the protection of fundamental rights. But however, till this point of time, we do not have a law in this particular regard. That means the Parliament has not exercised its power under Article 32 Clause 3. So what are the courts today in India is empowered to issue writs? Two courts. One is the Supreme Court under Article 32 and the High Courts under the article that you can see it in the comment box. I'm sure that some of the students will put the answers in the comment box. If you do not know the answer, I'll discuss that in the next class. Alright, so this is the basic understanding you should have. So I said that the courts can issue 5 types of writs. So what are the types of writs that can be issued by the courts? So the first and foremost type of writ that can be issued by the Supreme Court under Article 32 is what is called as writ of habeas corpus. So what do you understand by writ of habeas corpus? If you see writ of habeas corpus, to put it in a simple word, it means to have the body. What does it mean by to have the body? That means whenever an affected individual approaches the court is saying, produce that particular person in front of me. That means when this particular writ or directive is issued by the court is basically in case of what is called as illegal detention. Illegal detention of an individual. That means whenever an individual is illegally detained by any authorities, that is the state authorities, and therefore the affected individual who is detained, he is making a petition in front of the court that he is illegally detained. And because of the illegal detention, some of his fundamental rights is also violated. Now just recollect what could be the rights that may get violated in case of what is called as illegal detention. So for example, your right under Article 21 of the Constitution, right to life and personal liberty might get violated. Right under Article 22, because in case of arrest and detention, certain rights are available under Article 22. Right to be informed of the grounds of arrest, right to be produced before a nearest magistrate, and all those things. For example, let us assume that a person is arrested by the police and the police has not even given the reason as to why the individual is arrested. Neither the reason is given to the individual nor the individual is produced before the nearest magistrate within 24 hours. And he is kept in the police custody itself, say let us assume for 4 to 5 days. So in that particular case, will the affected individual have any remedy? Yes, he has the remedy that he can approach the courts. In fact, in this particular case, in the example that I have given, he can directly approach the Supreme Court of India under Article 32, and thereby he is bringing it to the notice of the Supreme Court that there is an illegal detention, therefore his right is violated. And when he brings us to the notice of the Supreme Court by filing a petition, then the Supreme Court will issue a writ towards the law enforcement authority, in this case the police. And what is the directive that will be issued by the Supreme Court? It will issue a writ of what is called as habeas corpus, which means that so and so individual has filed a petition to me, produce that particular person in front of me. That means to have the body. By issuing a writ of habeas corpus, the Supreme Court is directing the police to produce that particular person in front of the Supreme Court. And once a person is produced in front of the Supreme Court will decide the legality of such detention. The Supreme Court will verify whether that detention is legal or whether such detention is illegal. And if the detention is illegal, the Supreme Court will also see whether it has violated the rights of the people. So basically, by producing the person in front of the Supreme Court will be in a position to see whether the detention is legal or illegal, whether there is any violation of fundamental rights or not. And if the Supreme Court is convinced that the detention is illegal and therefore there is a violation of the fundamental rights, then the Supreme Court can provide remedy to the affected individual. the Supreme Court can even release that particular individual, order for the release of that particular individual. But however, if the Supreme Court finds that there is no violation of fundamental rights, then there is no remedy in the case. Because the remedy will be there only in case of what is called as a violation of the fundamental rights. So that means basically when this writ of habeas corpus is used, the writ of habeas corpus is basically used by the courts whenever there is what is called as an illegal detention. And by the illegal detention, if any of the fundamental rights are violated, then probably the court is going to issue this particular writ. The same is true in case of the high courts also. Even in the high courts, when there is an illegal detention, they can also issue writs. They can also issue the writ of what is called as habeas corpus. So this is basically what you'll have to understand when it comes to what is writ of habeas corpus. But the most important thing is, does the principle of locus standi applies when it comes to what is called as writ of habeas corpus? Now, what exactly is this principle of locus standi? Thus, the locus standi applies in case of writ of habeas corpus. So, to understand whether the principle of locus standi applies in case of writ of habeas corpus, first we'll have to understand as to what is locus standi. Now, locus standi means that basically only the affected individual should knock the doors of the judiciary. That's a conventional principle that was followed by the judiciary till 1970s. But subsequent to 1970s, today the judiciary has liberalized this particular principle of locus standi. So before we understand all those things, first let us try to understand as to what is this particular principle of locus standi. Locus standi means that whenever an individual is approaching the court is asking, what is your interest in this particular case? Or in which way you are affected because of this particular case? Do you have any direct interest in this particular case? Then if there's a direct link or a direct establishment is there between the person who's going to the court and the case he is bringing in front of the court, then there is what is called as locus standi. So now the question is, does the principle of locus standi applies in case of filing writ of what is called as habeas corpus? The court has made it very clear the principle of locus standi does not apply. I'm repeating it again, the principle of locus standi does not apply. So what does it mean when I say the principle of locus standi does not apply? That means it means not necessarily the affected individual has to approach the court to file a writ of what is called as habeas corpus. Even some unrelated people through a public interest litigation can also bring it to the notice of the courts. In fact, there's one famous case which is called as a Husainara Khatun case. I'm not sure how many of you heard it. Husainara Khatun case, which is considered to be one of the most important earlier public interest litigation. Husainara Khatun. So, case, I think the year of the case is 1979. It is considered to be one of the most important public interest litigation in the early stages when the public interest litigation was evolving as a concept. PIL, which is also called as a public interest litigation. So, public interest litigation is basically what? It is a litigation that is brought in front of the court, not by a person who is directly affected because of a particular case, but by a public spirited individual on behalf of others in the society. That's basically what is called as a public interest litigation, which means that if something happens to anyone in the society, that those affected individuals are not going to the court, and because they are not able to go to the court, there is a third party, there's a person, a public spirited individual who's looking all those things, and he feels that they do not have the resource. So on their behalf, I will file a case. I have no direct interest in this particular case, but still I have a public interest because my fellow citizens are getting affected, and for that particular reason a petition is filed, and that's basically what is called as public interest litigation. So what is the basic understanding you will have to have with regard to writ of habeas corpus? The court has made it very clear that when it comes to writ of habeas corpus, it is not necessarily it should be filed only by the person who is arrested. It can be filed even by a public spirited individual. So that is exactly what has happened in what is called as Husainara Khatun case. In Husainara Khatun case, a newspaper article came. It was published in the Indian Express newspaper, I think, wherein it came or brought to the notice of the public that the plight of under trials in the jails of Bihar. When it under trials means that these are people who are accused of some crime, but they are not yet convicted in a court of law. They are just accused of some crime, and they are not yet convicted in a court of law. That means the trial is going on. The trial has not been completed. but the trial has not been completed, but still they are put in what is called as the judicial custody, because they are in judicial custody for a long time for the reason that they do not have the money to get the bail or the bond, whatever it is. And for that reason, they continue to be in judicial custody, or they continue to be in jail for a long time. And a newspaper article came wherein a local lawyer read this particular news. He was astonished to see this news that there are a lot of under trials in the state of Bihar who are under trials for 5 to 10 years. They continue to be under trials for a long period of time. That even if the punishment is given after the trial is over, they would not have been in the jail for such a long time. And just because these people are illiterate, just because they are not aware of their rights to go to the court and get the bail and all those things, they continue to be in the jail for a long period of time. And subsequently, the lawyer has returned to the Supreme Court of India. And that letter was considered to be what is called as a public interest litigation. And therefore, that led to the release of lot of under trials in the state of Bihar. So that basically came to be what is called as a Husainara Khatun case. So the basic understanding is, even if you're not aware of the Husainara Khatun case, that is not important. The basic understanding you should have is that the principle of locus standi does not apply. So I'm just repeating it again. Does the principle of locus standi applies in case of writ of habeas corpus? No, the principle of locus standi does not apply. So this is basically your understanding. So what is habeas corpus? Habeas corpus means to have the body. And the idea is, by issuing this order, the court is going to see whether the detention is legal or illegal. And if the detention is illegal, then the remedy may be given to the individual. That's basically what is called as writ of habeas corpus. The next writ is writ of mandamus. Now, what do you understand by writ of mandamus? Writ of mandamus basically means we command. So who can command? Of course, only the court can command. Others cannot command the court will command. So when the court is going to command? Suppose, say, let us assume I am a citizen, my fundamental right is violated, and I take this to the notice of the court that my fundamental right is violated because of what reason? That the state has failed to perform its duty, or any public authority has failed to perform its duty. Now try to understand, the writ of mandamus does not apply against a private organization. It applies only against what falls within the definition of state, and that's why you'll have to understand as to what falls within the definition of state under Article 12 of the Constitution. For the students who are not having an idea as to what falls within the definition of state under Article 12, please go to my previous lecture. One complete lecture I have explained as to what falls within the definition of state. That means anything that falls within the definition of state, or any public authority which falls within the definition of state, and they are supposed to perform certain functions and they fail to perform certain functions or duties. And because they fail to perform certain functions and duties, therefore it results in the violation of the fundamental rights. And in that particular case, the affected individuals can approach the court, and the court can issue a direction of what is called as mandamus. Mandamus basically means we command. That means the court is directing the concerned public authority to perform that particular duty, because non-performance of that particular duty has resulted in the violation of the right of the people. That's basically what you'll have to understand. Okay, now just take a moment and think, what type of duty if the state fails to perform, and if they don't perform certain things which may result in the violation of the fundamental rights. Just think about it. And people who are in the cities especially, it's a very easy example. Say, let us take the example of Delhi. One recurring incident that is happening in Delhi for the last 4 or 5 years is what is called as pollution in Delhi. And if the state is not controlling the pollution, then people are affected because of the pollution. And if people are affected because of the pollution, then that is directly violating their right to clean environment, which is a fundamental right under Article 21. That means many times public interest litigation has been filed in the high courts and the Supreme Courts of India, that saying that the state has not done enough, so therefore the pollution is affecting the right to clean environment of the people. So in all those cases, the Supreme Court and of course the high courts have also directed the state government or the state to take various actions in order to control the pollution, because it is their responsibility to control the pollution and therefore ensure what is called as right to clean environment. This is one example. Can you just think of other example? For example, right to education is a fundamental right. So the state has to provide free and compulsory education up to 14 years of age to the children in this particular age group. So suppose if this is not implemented, and therefore if the right of any of the child is getting affected, so they can approach the court, and the court is going to issue a writ of what is called as mandamus. So mandamus basically means what? Mandamus basically means we command. We command means the court is commanding any public authority to perform their duty, because non-performance of that particular duty has resulted in what is called as the violation of the fundamental rights. That's basically what you'll have to understand. But the key word here is what is called as public authorities. It cannot be issued against what is called as a private authority. But however, there's an exception to this, that we have seen that even a private authority can fall within the definition of state under certain circumstances. So that is why your understanding of state is very, very important. So can you just recollect under what circumstances a private authority can fall within the definition of state? A private authority can fall within the definition of state when the private authority is acting as an agency or an instrument of state. And when a private authority can act as an agency or an instrument of state, when a private authority is in collaboration with the state, when a private authority is performing certain duties which are governmental in nature. So, or they are helping the government in performing some of the duties which is a responsibility of the government to do. So, under such a circumstances, even a private authority may also fall within the definition of state. And when they fall within the definition of state, if we have not performed any duty, therefore it resulted in the violation of the rights of the people. Under such circumstances, the court can issue writ of mandamus even against a private authority. Otherwise, they cannot issue writ against a private authority unless and until they act as an instrument or an agency of state. Be very, very clear in your mind. Of course, one last point is also of great significance before I move to the next topic, that is the writ of prohibition. The next thing that you have to understand is, does the principle of locus standi applies in case of what is called as writ of mandamus? Now, even in case of writ of mandamus, the principle of locus standi does not apply. That is what you'll have to understand. What does it mean when I say it does not apply? It does not apply means not necessarily only the directly affected individual whose right is violated because of the non-performance of duty by a public official has to approach the court, but on his behalf, any other public spirited individual can also approach the court. Suppose if my right is violated because the state has not performed its duty, I can also approach, but on my behalf, some other individual can also bring it to the notice of the court in the form of what is called as public interest litigation. So here also the principle of locus standi does not apply. So the principle of locus standi does not apply both in case of mandamus, also in case of what is called as habeas corpus. Now let us move to the next thing. What is the next thing? That is prohibition. So what is this particular writ? So this is quite simple. What is prohibition? Prohibition is basically a writ which is issued by a higher court towards a lower authority. Prohibition is a writ which is basically issued by a higher court towards a subordinate court. So when a high court or a Supreme Court can issue writs towards a subordinate court, that is the writ of prohibition. When a subordinate court or a tribunal is trying to exceed its jurisdiction, it can be issued both against a judicial as well as a quasi-judicial body. So basically the writ of prohibition means what is called as forbid. Forbid means to stop. That's basically what is called as forbid. To prevent someone from doing something, that's basically what is called as forbid. Now what is this writ of prohibition? So writ of prohibition means that this is a writ which is issued by the Supreme Court or the High Court towards the subordinate courts or through any of the quasi-judicial authorities as well, not necessarily the judicial authorities. So for example, the district court and the other subordinate courts are judicial authorities. But say let us assume tribunals in our country, like the Central Administrative Tribunal, National Green Tribunal, there are tribunals and they are quasi-judicial in nature. So this writ of prohibition can be issued by a higher court towards a lower court. And under what circumstances this particular writ of prohibition is used? This writ of prohibition is used especially when they try to exceed their jurisdiction. That means it is not within the jurisdiction of a subordinate court or it is not within the jurisdiction of a tribunal to entertain certain case in the first place. But they are trying to entertain such a case. Not only they are trying to entertain, but they are also hearing, they are also conducting trial in that particular case. And under such a circumstances, the higher court can issue a writ of what is called as prohibition informing the lower courts that you do not have the jurisdiction to look into this particular case. So you better not look into this particular case. You better not pass any orders in this particular case because you have no legal jurisdiction in this particular case. And that order which is pointed towards a subordinate court from a higher court is what is called as writ of prohibition. So prohibition basically means to forbid, or in other words, the writ of prohibition is basically used to prevent a lower court from exceeding its jurisdiction. That is why the writ of prohibition is also what is called as preventive in nature. So this is the basic understanding you should have. So it is basically how the writ of prohibition works. The writ of prohibition is basically preventive in nature. The most important thing that you have to keep in your mind is that the writ of prohibition, when it comes to the principle of locus standi, the principle of locus standi applies in case of what is called as writ of prohibition. That means only the affected individual can bring it to the notice of the court, and therefore the court can issue what is called as a writ of prohibition. So this is basically what you'll have to understand. By issuing a writ of prohibition, what the higher court wants from a lower court? The higher court wants a lower court to be inactive. Do not take any action in this particular matter because you are not having the jurisdiction. This is basically what is called as writ of prohibition. So once you have understood the writ of prohibition, your understanding of certiorari becomes very easy. What is certiorari? Now certiorari means to be certified. What do you mean by to be certified? To be certified means whatever the order that is issued by a lower court is also to be certified by a higher court that the order is correct or it does not have any error. So that is basically what is called as to be certified. Now when this writ of certiorari is issued by a higher court upon the orders of the lower court is when that the lower court has passed some orders where there is an error in that particular order, or the lower court has passed an order where it does not have the jurisdiction in the first place to pass such an order in the first place. Under such a circumstances, a writ of certiorari can be issued by the higher court towards a lower court. That's basically what is certiorari. Or in other words, say suppose let us assume that a matter is taken up by a lower court where it does not have the jurisdiction to look into that particular matter in the first place. But the lower court has already passed an order in this particular case, but they are not having the jurisdiction in the first place. But by mistake, they already passed the order. But that order is not an appropriate order because the lower court has no jurisdiction to pass that order in the first place. But still they have passed it. The higher court was not aware of this. If they were aware of this, they could have issued a writ of what is called as prohibition and prevented the lower court from exceeding its jurisdiction. But here the lower court has already exceeded the jurisdiction, or it has already committed the mistake. But there should be someone to rectify this mistake or correct this particular mistake, and that is what is done by the higher court by issuing a writ of what is called as certiorari. While the writ of prohibition is preventive in nature, where the writ of certiorari is what is called as curative in nature. That means whenever the writ of prohibition is not used, or the error has already been committed, or the order has already been passed by the subordinate court, so on top of that, what type of writ may be issued by the higher court is what is called as writ of certiorari, to quash the order that was passed by the lower court, to nullify the order that was passed by what is called as the lower court, because that order is having error, or that order is not a valid order. That order was in excess of what is called as the jurisdiction, and that is basically what is called as certiorari. And this order can be issued by the higher court upon the lower court, or it can be issued against a judicial, quasi-judicial, or even against an administrative order. When I say judicial, the subordinate courts. When I say quasi-judicial, the tribunals. When I say administrative authorities means orders issued by the government officers and all those things. Even against that, it can be issued. So this is basically what you'll have to understand with regard to what is certiorari. But the most important principle that you have to keep in your mind that even in case of certiorari, the principle of locus standi applies. So far we have seen 4 things. Out of the 4 things where the principle of locus standi does not apply, the first 2 things, that is the writ of habeas corpus and the writ of mandamus, and where the principle of locus standi applies in writ of prohibition and writ of certiorari. So I am just making it very clear. While writ of prohibition is preventive in nature, whereas the writ of certiorari is curative in nature. Okay, so that is what, there it is to forbid, here it is to certify. That's basically what you'll have to understand. Come to the last writ, that is basically what is called as writ of Quo-warranto. So what is this writ of Quo-warranto? So writ of Quo-warranto is again an interesting writ that is issued by the courts. So basically this writ is issued by the courts to determine the legality of someone occupying a constitutional office. The legality of someone occupying an important post in the government. The legality of someone occupying what is called as a statutory post. Suppose, say for example, somebody is appointed as a chief minister, and any interested person can go and file a petition and seeking the intervention of the court, saying that the so and so person is appointed as a Supreme Court does not have the legal qualifications to be appointed as a chief minister. Someone who is appointed to any constitutional post does not have the legal qualification to be appointed as to that particular constitutional position, be it the Election Commission of India, be it the chairman of Union Public Service Commission, be it the Finance Commission, whatever it is, or even to important statutory positions like the chairman of NHRC, like say let us assume the governor of RBI. These are all statutory posts which is created by way of a law. So when this writ of Quo-warranto is used, so whenever a writ of Quo-warranto is filed in front of the court, then it is filed to the court, so that the court looks into the legality of someone occupying a particular office, whether the person is having the legal position or all the legal qualifications, or he does satisfy all the criteria as per the law to qualify a particular office. And that's basically what is verified by issuing a writ of what is called as Quo-warranto. That means on what authority or by what warrant you are occupying a particular office. So whenever this writ is directed towards a particular public authority, that authority has to prove it in front of the court that he has got all the legal qualifications to hold on to this particular office. Say for example, once this writ of Quo-warranto was filed against the Chief Minister of Tamil Nadu, J. Jayalalitha, because at that time there was some corruption case against her, but still she was appointed as a Chief Minister. So a writ of Quo-warranto was filed, and therefore the court asked, what is your legal standing, or what is your warrant, or what is the legal qualification you have got to occupy that particular office. And similarly, once this writ of Quo-warranto was filed against then Chief Vigilance Commissioner of India, Mr. P.J. Thomas was the Chief Vigilance Commissioner. So against him also it was filed. So irrespective of outcome of these cases, that is not very important, but you should understand when this writ of Quo-warranto is used. The writ of Quo-warranto is used to check the legal qualifications of someone to occupy certain public office, especially important constitutional or statutory office. This is the basic understanding you should have. So once this writ is filed, then probably the concerned public authority should prove that they have all the legal qualifications to hold on to a particular office. So they have all the authority, or they have all the warrant to hold on to that particular office. And if they fail to establish this in a court of law, then they cannot continue in that particular office. And that's basically what is called as writ of Quo-warranto. In fact, one important principle of writ of Quo-warranto is, even in case of writ of Quo-warranto, the principle of locus standi does not apply. So this is basically what is called as writ of Quo-warranto. So very quickly, what is writ of habeas corpus? Writ of habeas corpus means to have the body. It is used to determine the legality of the arrest or legality of detention. If the detention is legal, then no remedy. If the detention is illegal, remedy. The principle of locus standi does not apply. Mandamus. This writ is issued when a public authority failed to perform their duty, because of which the fundamental rights get violated. So under such circumstances, the writ of mandamus is issued. The principle of locus standi does not apply. What is prohibition? When a lower court is trying to exceed its jurisdiction, and that is prevented by an order which is issued by a higher court. That is basically prohibiting the lower court from exceeding its jurisdiction, which is basically preventive in nature. Principle of locus standi applies. Certiorari. If the lower court has already exceeded the jurisdiction, and thereby there is a violation of the right, and therefore this order have to be rectified. This order has to be quashed. So therefore the higher court issues an order, and that's basically what is called as writ of certiorari. That is, it is also what is called as curative in nature. While the writ of prohibition is preventive in nature, writ of certiorari is curative in nature. The principle of locus standi applies. Writ of Quo-warranto. So quo-warranto means basically the court is asking by what authority or by what warrant you are occupying an office. What is your legal qualifications, or do you satisfy all the criteria to occupy that particular office? Then if they prove it, it's okay. If they fail to prove it, then the office bearer has to vacate the office as per the direction of the court. The principle of locus standi does not apply. But one thing that you have to keep in your mind when it comes to the writ of quo-warranto, so the writ of quo-warranto is not directed against each and every government office. No, it is only against the important governmental office. In fact, in your book it is given it is not applicable against the ministerial office. So students have a misunderstanding when I say ministerial office. They do a misunderstanding that ministerial office means minister. No. So try to have an understanding. Ministerial is a colonial legacy. Ministerial means clerical job. All clerical jobs are called as ministerial offices. So basically they involve in maintaining records and all those things. These are all clerical office, usually group C and group D post. So the writ of quo-warranto does not apply against a ministerial office, but it can apply against the ministers because these are all constitutional in nature. So it can apply against the ministers because the Council of Ministers reference is there in the constitution. But it does not apply against what is called as ministerial office. It may apply only against a important constitutional post or the statutory post. That's basically what you'll have to understand. So with that, let us quickly go to the question. Look into this particular question, and very good question. Try to put the answers in the comment box. A citizen of India belonging to a particular state feels that the Chief Minister, who has recently assumed the office after the election to the Legislative Assembly, does not have the necessary qualification to hold on to such office. In such a case, he wants to challenge the appointment of the Chief Minister in a court of law. What would be the appropriate writ by which he can challenge such appointment? Is it writ of Certiorari, writ of Mandamus, writ of Prohibition, writ of Quo-warranto? So please put your answers in the comment box. So with that, we are almost coming to the end of the fundamental rights. We have not yet completed it. We have to see a couple of other lectures before we complete the fundamental rights. And then we'll move on to the directive principles of state policy. So if you have any questions or queries related to this particular lecture, you can always reach out to me through my Instagram account or through my Telegram channel. Not only with regard to this particular lecture, but for the other lectures as well. Anything or any doubt related to the exam also, you can reach out to me. And apart from this, one small request is, if any of your friends or family members are preparing for the UPSC examination or any competitive examination, please refer them these videos, and it will be immensely beneficial for them during their preparation phase. Alright, so with that, I'll wind up my lecture for today. Thank you very much. Keep watching. All the best.